There is so much good sense in this paper that, I'm tempted just to say, read it and be sure to read all the footnotes and read all the way through and then sit down and maybe let Tom talk some more. But that's not what we do. That's not settled practice. So
There's no precedent for that, right?
No precedent for that. So, I'm going to offer some comments and maybe a few quibbles and then underscore some things that I think are particularly significant in the paper. I'm going to sort of begin with a few things that may be the most obvious and move to some things that may be a little less obvious. The most obvious is Tom Merrill is not an originalist. Now, that's not a surprise. The author of I still remember his great article, Burke, Not Bork.
Bork v. Burke.
And so who would think he is an originalist? But in a sense, he's not an originalist in a more profound sense in that he's not even an anti-originalist. It's that originalism is fine as long as it's part of our practice. What I think Tom turns out to be is a sort of thoroughgoing positivist. His formula reminds me of Oliver Wendell Holmes saying, that law is nothing other than a prediction about what judges are going to do. Now, Tom reframes that in a way which I think makes him a much better, more plausible, and more inspirational Oliver Wendell Holmes, and that it isn't the judge that we're looking at, but rather the parties, and especially the losers in an adjudication, as advised by their lawyers and what their expectations are. And so, his definition is that a category of norms will be regarded as legitimate if it conforms to the expectation of the parties as advised by their lawyers. And that cashes out pretty much to be what are the norms of our practice. So we look around, and he has an empirical side to the paper in which he makes claims as to what kinds of arguments, in fact, are regarded as legitimate and which kinds are a little bit dicier, but legitimate only under some circumstances. And if I understand the methodology here, for the most part, what he's doing is looking at what courts actually do. Couple of quibbles here. First of all, I wonder, toward the end of the paper, Tom talks about precedent. So toward the beginning, precedent is a firm part of our established practice. Toward the end of the paper, he says that a particular style of precedent using has taken over. He associates this with Justice Scalia, and it gives it the charming title of Scrabble board precedent. And Scrabble board precedent is one where the adjudicator sort of takes snippets of text and quotes and out of context and puts and can read precedents very narrowly or very broadly, and it all turns out to be a smokescreen for the adjudicator's own preferences. So if that is so, then that, I think, impugns Tom's claim that moral and social policy arguments are not part of our settled practice. Apparently, our settled practice is to let moral and social policy arguments dominate, but to lie about it. So prevarication turns out to be our settled practice, and that's, I think, I don't know quite what to do with that. There is the Rochefoucauld argument of hypocrisy being a tribute that vice pays to virtue. So maybe this is, in a sense, a kind of the virtue being pointed to through hypocrisy and prevarication may be something more uplifting. But I just kind of wonder if our legal theory is going to be positivist, if it's going to be based upon current practice, and if current practice is, in fact, as Tom describes it, where are we? So that's a quibble. And then I also am interested in, what are the moving parts? What are the which variables are endogenous and which ones aren't. So practice, where does it come from? It's the parties as advised by their lawyers. But what makes lawyers advise their parties in particular ways? That's what I'm most concerned about. Is it because they went to law school and people like us have been teaching them, in which case it may turn out to be, that we're fairly high in the food chain. I think judges are probably the highest in the food chain because they are able to create norms, practice. Nino Scalia, for example, with hardly anybody really agreeing with him, has made the citation of legislative history. Hasn't made it go away, but he certainly has made it look a little suspicious. So I don't think judges in our system, cite legislative history with the kind of promiscuous confidence that they did when I was a law clerk, where the legislative history was everything. Scalia, one man, has changed practice, and I think so. Judges, I think, are very influential. I think law professors are influential, and so what are we influencing? I think becomes important, and I think maybe a little bit of normativity ought to be smuggled back in. So, third point. This is just to underscore what I think is Tom's most important point, and in his presentation, he gave this like a sentence or two. And his point is, to be legitimate as a basis for decision-making, moral claims have to command a consensus. Now, I think that's and he says the same thing about social policy arguments. I think that's a very important claim. I'd like to see a lot more in the paper about why it's true. I share it, but I'd also like to hear, Jack Balkin's reaction to this. I find so Jack was just explaining the dual legitimacy, and the second part of it is that it has to be our Constitution, right? Our Constitution, and his book is just filled with the first person plural. We believe this. We believe this. The other thing, and I think the first person plural is an extremely dangerous and misleading part of the rhetoric here. Our Constitution. What do we do, though, if the moral principles are contested? As in almost every important constitutional case, they are. The ones where they're not contested are not important constitutional cases. And the way I see practice is that the legal elite gets to win. That because we have empowered the courts to be the adjudicators, and because the courts are the legal elite, and they listen to people like us and to a certain segment of the population, the legal elite gets to decide these questions. And that, I think, is really the most fundamental a problem here. And I really would like to hear Jack engage with Tom about this, because I think this is the essence of much of Jack's work, is to say, yes, and the legal elite ought to prevail, but he doesn't call it by its right name. He doesn't call it the legal elite. He calls it we, us, our, right? As if doing things like striking down the enactments of democratic legislatures and the products of referenda somehow represents us, right? And that's the way we build legitimacy for the Constitution. But every time that happens, there are other people who are equally citizens, equally part of this republic, who say to themselves, why didn't our votes count? I thought we voted on that question. And there doesn't seem to be anything in the Constitution that says otherwise. What's going on? And that's, I think, a legitimacy problem as well. And so toward the end of the paper, Tom makes some interesting observations. He says that the farther you are from the enactment, that he points out that there is an argument, and this relates to Christina's paper yesterday too, and I think this is absolutely true. The farther you are from an enactment, and especially where different segments, different factions, groups, demographic groups, whatever, were not represented at the beginning and now are represented, that this presents a problem. And I think the common argument is that the solution to that problem is to adopt a form of constitutional interpretation which is more flexible, more amenable to non-originalist, non-objective forms. Tom says, no, actually a better solution to that would be to say that when you're facing that kind of a question, that instead it's proper for the legislative process. I think I want to underscore that because I think it's an important point that he is making. And then finally, he tells us that because of all this Scrabble board stuff and the disconcerting fact that the justices of the Supreme Court seem to decide things according to their own preferences rather than to anything that's based on, objective legal analysis, that is undermining the public sense of legitimacy. And he says it's going to drive us toward arbitration and so forth. So what I think at the end of the paper we see is that it's not turtles all the way down. It's not just positivism all the way down. At a certain point below the turtles, you have citizens who believe in the rule of law and believe in democracy, and that matters. Hence, well, maybe at the end of the paper, Tom is turning into an originalist after all.
Tom, you have any thoughts on that?
No, I don't have anything to say. That's great, Mike. Thank you very much for amplifying and qualifying what I say. I guess I'm trying in this paper to sort of keep this distinction between a sort of descriptive account of legitimacy grounded in sort of practice, social practice of lawyers and courts, and then keep the normative parts separate. If this ever evolves into a larger project, the normative aspect, of course, will loom much larger, but I want this, at this point at least, to try to keep them somewhat separate. So there's no question but that the social practices do evolve over time. Your citation of the use of legislative history is a good example. Some recent empirical work suggests that lawyers that practice law have not completely assimilated the sort of new textualist critique of legislative history. They still cite legislative history, and there's an article by Abby Gluck and Richard Posner, which is based on the interview of 42 Circuit Court of Appeals judges, in which over half of them say that they're a textualist, but they all say, well, I look at legislative history anyway. So social practice does evolve, but it doesn't necessarily evolve quite as sharply as maybe some of the theorists would suggest that it should. Precedent, the thing about precedent at the end in particular is this, I think, is really critical. I think all this discussion that we've had here at this conference, and I suspect at previous conferences, has been very much focused on how to understand the original meaning of the Constitution and so forth. How should that cash out in terms of today? What's actually going on is that, constitutional law has become a common law system. It's based on precedent to a very large extent. So a lot of the intellectual energy really ought to be transferred to trying to understand how this precedent is working or not working in making this sort of ongoing constitutional convention operate. And I haven't given this enough deep thought myself, but the bit about Scrabble board constitutionalism is sort of a preliminary thought that maybe some things that are not so great are happening in this realm of precedent, and that something ought to be done to rein it in. Mike is absolutely right that at heart I'm an originalist in the sense that I'm a small d Democrat. I strongly believe that public policy ought to be made, if possible, with some kind of interaction between the people, their elected representatives, and the people that interpret the law. My big problem with constitutional law is that the Constitution is almost 230 years old. The 14th Amendment's 150 years old this year. And there's no, we haven't had a constitutional amendment proposed and ratified in 40 years. So there is no longer a dialogue between the people, the unwashed masses, and the people, the elites that engage in constitutional discourse. And I think that is a very serious problem. I think that I tremble that originalism can operate in that kind of universe. I think it can operate and does operate in a universe where there is a frequent engagement between the people and the enactors and the interpreters. And my ultimate normative desire would be to try to get back to a world that's more like that.